Welcome to First Do No Harm with Massachusetts Citizens for Life board member and physician Dr. Mark Rollo. This broadcast will focus on medical ethics from a Catholic perspective and address abortion, physician-assisted suicide, contraception, natural family planning, IVF, healthcare proxy, and other topics. Please be advised that this show may not be appropriate for children under 13.
Hello and welcome back to First Do No Harm, a show about medical ethics from a Catholic perspective. I'm Dr. Mark Rollo. Last time in part 2 of my interview with attorney and executive director of Massachusetts Citizens for Life, Patricia Stewart, we discussed legislation that she has submitted on behalf of MCFL to fight the unjust laws regarding abortion. The legislation that she submitted consists of 5 separate life-affirming bills, which seeks to chip away at the horrendous pro-abortion laws that exist in the Commonwealth of Massachusetts. In part 1 of the interview, we discussed 2 of these bills, and in part 2 of my interview with Pat Stewart, we discussed the other 3. Today, we will discuss a pro-abortion related bill filed by the proponents of abortion that seeks to even further expansion of the evil of abortion in Massachusetts. Let us first, as always, begin with prayer. For, as stated by the U.S. Catholic bishops, only with prayer that storms the heavens for justice and mercy, prayer that cleanses our hearts and souls, will the culture of death that surrounds us today be replaced with a culture of life. O God, your servant, St. Thomas Aquinas, once stated that the aim of philosophy is not knowing what men have thought, but what is the truth of things. Some men and women erroneously think that abortion, especially medical abortion, is no big deal. And many celebrate abortion as a sign of liberation and equality. Nothing could be further from the truth regarding a process which takes a life and damages another life, all the while feeding the multi-billion-dollar industry of abortion. Help us to realize that all life is precious. All life is a gift. And all life must be cherished. And we ask this in Jesus' name. Amen. It bears repeating that the impetus behind the filing of the 5 pro-life bills that we have discussed over the last 2 shows was a response to the Massachusetts Roe Act legislation, which in turn was a response to the expectation that Roe v. Wade could be overturned in 2022. In that event, abortion wouldn't go away. Rather, the laws regulating abortion would go back to the states, and hence the desperate passage of the Roe Act by the Massachusetts legislature on the day after Christmas, 2020. While states like Mississippi and Texas and many others have moved to protect the unborn and their mothers by passing pro-life laws, Massachusetts responded in the polar opposite way, doubling down on death by trying to codify Roe v. Wade into law with the demonically extreme Roe Act, which allows abortion up until the time of birth, even legalizing passive infanticide, and the further endangerment of women by allowing late-term abortion, a very dangerous procedure, to take place outside of a hospital, in a clinic. As I mentioned in the last show, only 7 out of 198 countries in the world allow elective abortion after 20 weeks of pregnancy. Sadly, the United States of America is one of these 7 countries, which puts us in the company of countries like communist China and North Korea, countries which have terrible records on human rights. The Roe Act, passed by the Massachusetts legislature, makes our state one of the most brutal and heartless jurisdictions in the world regarding abortion on demand. Again, the Massachusetts Roe Act would do the following. It would allow abortion in Massachusetts during all 9 months of pregnancy. It eliminates any requirement that even late-term abortion be performed in hospitals. It eliminates the requirement to make efforts to care for a child who survives an attempted abortion. And it eliminates any requirement that a pregnant minor over the age of 15 have any adult consent, parental or through the courts, before undergoing an abortion. This is extreme. According to the Charlotte Lozier Institute, the research arm of the Prolife Susan B. Anthony list, only 3 of the 42 European countries that allow elective abortion permit elective abortion after 15 weeks gestation. The Mississippi late-term abortion restriction at 15 weeks is not extreme by any measure when compared to European law. And it is this Mississippi law, Dobbs versus Jackson Women's Health Organization, which was passed in 2018, which limits elective abortion to 15 weeks, which will be heard by the United States Supreme Court beginning in December. Roe v. Wade could be thrown on the ash heap of history, where it belongs. Massachusetts, as mentioned, has gone in the opposite direction of Mississippi and Texas, and it is the Massachusetts legislature that is extreme, as it has removed virtually all restrictions to protect babies, and it endangers women in the process. We are therefore left in this state with a task of trying to incrementally roll back this egregious Roe Act. The 5 bills filed by Pat Stewart on behalf of MCFL seek to do just that. Let's briefly review these bills. The first one, House Bill 1535, an act relative to unborn victims of violence. The main cause of fetal death is maternal death secondary to blunt force trauma of the abdomen. Most fetal deaths occur early in pregnancy. Currently, at least 29 states have fetal homicide laws that apply to the earliest phases of pregnancy. Massachusetts case law recognizes viable unborn babies as victims of violence in instances of vehicular homicide and involuntary manslaughter. However, Massachusetts law does not recognize the unborn child as a victim of violence at earlier stages of prenatal development, that is, earlier than 24 weeks. House Bill 1535 seeks to cure this deficiency by defining an unborn child as the individual human life in existence and developing from conception until death. The second bill is House Bill 1534, an act to establish criteria to assess the maturity of a minor seeking an abortion, and this pertains to minors less than 16 years old. In Massachusetts, a pregnant minor under age 16 who is not married, divorced, or widowed and wants to get an abortion must obtain the consent of at least one parent or guardian, or apply to the Superior Court to obtain the consent of a judge. The process of applying for a judge's consent to a minor's abortion is known as the judicial bypass procedure. The current judicial bypass law does not even provide any guidelines or standards for a judge to follow in assessing a minor's maturity or immaturity. House Bill 1534 seeks to fill this void by establishing criteria that a judge can apply to determine the maturity of a pregnant minor who wants to obtain an abortion without parental consent. To improve transparency in the judicial bypass procedure, the bill also requires judges to keep yearly records of the number of petitions filed, the number that are granted or denied, and the age of the applicants. The judge is to send this record to the Commissioner of Public Health, who is required to report this data to the General Court annually. Currently, none of this is being done, and decisions are made in a very non-transparent way. The third bill was House Bill 2409, an act relative to victims of Down's syndrome. In Massachusetts, 49% of babies diagnosed prenatally with Down syndrome are aborted. This bill seeks to stem the tide of discrimination against unborn children diagnosed with Down syndrome and steer us off the path of selective reproduction. This bill will preserve the life of individuals with the capacity to further enrich the fabric of society in Massachusetts just by being alive. The fourth pro-life bill is House Bill 3005, an act relative to taxation, or taxpayer conscience protection. Massachusetts now spends your income tax dollars to pay for abortions, whether you like it or not. Bill 3005 seeks to remedy this inequity by giving taxpayers an option to indicate on their tax income form that they want the portion of their taxes that would go to fund abortion instead be used to promote and support the Baby Safe Haven program. This initiative permits a desperate parent to surrender a newborn to a designated facility, hospital, police station, fire station, without incurring criminal liability. And finally, the fifth pro-life bill is House Bill 662, an act relative to instruction in pregnancy and prenatal care. Although the recently passed Frameworks curriculum mentioned that the human life cycle is included in the areas of study, scant, if any, attention is paid to the beginning of the human life cycle, which is the period of physical development and growth of the human baby in utero, the time in which the most dramatic changes in human development are occurring. A student's knowledge of the human life cycle is incomplete without instruction on prenatal development and growth. This bill seeks to cure this deficiency by mandating for 7th, 8th, or 9th graders to be instructed in prenatal human development, consistent with the accepted teachings of the National Institute of Health that includes anatomical and physiological characteristics of unborn children at increments of 4 weeks from fertilization to full term. A fair, fact-based appreciation of the humanity of the child in utero may help to deter teenage pregnancy in the Commonwealth. In addition, House Bill 662 mandates instruction on postnatal care. Now, I would like you to hear part 3 of my interview with MCFL Executive Director Pat Stewart as we discuss House Bill 2399, which is also Senate Bill 1470, which was introduced in the House by Representative Lindsay Sabadoza and in the Senate by Jason Lewis. This bill would mandate all 13 public university campuses in Massachusetts to either provide the abortion pill or refer students to abortion providers. In our remaining moments, now that we've gone over the 5 bills that you've submitted, I'd like to briefly have us talk about a bill that was submitted by pro-abortion individuals. Primarily, this bill was authored by Jason Lewis, and the act, it's Senate Bill 1470, and it is entitled An Act to Require Public Universities to Provide Medication Abortion, which is just unbelievable to think that if you're sending your daughter off to college, that one of the services they get at the college is, services in air quotes, is to take an abortion pill if they become pregnant. What are your thoughts about this, Pat?
Well, you were also so eloquent in opposing this, and I'll let you remind folks of what you had to say on this. But my comment was that convenience is a powerful selling point for so many products and services today. In healthcare, you can go to Stop and Shop, pick up a box of cornflakes, and while you're there, get a flu shot, and it's no big deal. The problem with the convenience that this bill, which is, as you said, Senate 147 and House Bill 2399, what this bill offers is that a medical abortion is a big deal. The Mayo Clinic describes it as, quote, a major decision with emotional and psychological consequences. Putting healthcare centers on a public university grounds to provide medication abortion for students fosters the false impression that a medical abortion is no big deal, because typically a campus health center handles relatively minor maladies and injuries. Mm-hmm. So it would be reasonable for an anxious student who is trying to seek a quick and easy solution to an unwanted pregnancy to assume that, the health center would be similarly easy and no big deal. Yeah. However, this would be a dangerous assumption, because a student who minimizes the seriousness of the medical abortion and deludes herself into thinking it's something other than an abortion risks life-changing psychological and emotional harm. And on this, the National Abortion Federation had a statement, and it said, quote, it's important for a patient's post-abortive well-being that she does not fool herself into thinking she's not having an abortion, and that the provider does not participate in her self-deception. This caution is important because the risks are real. Mm-hmm. The American Psychological Association's Task Force on Mental Health and Abortion reported in 2008 that some women do experience sadness, grief, feelings of loss following termination of a pregnancy, and some experience clinically significant disorders such as depression and anxiety. Mm-hmm. In fact, one of the task force's independent researchers showed that 2 years after the abortion, 38% of women who participated in the original study had symptoms for abortion-specific post-traumatic stress disorder.
Mm-hmm.
You know, the college campus is an environment that is not conducive to major medical decision-making. It's where students live and learn, and they go to engage in life-enhancing pursuits to prepare themselves for futures as adult members of society. Putting a medical abortion facility on its premises sends a misleading message that a medical abortion is not a serious matter. And I think that universities, colleges, and the Department of Public Health are thus, in pursuing this route and this endeavor, are becoming complicit participants in a pregnant student's potential self-deception, and all to her great detriment to whatever follows. Yeah. So I have urged that committee, which is the Joint Committee on Public Health, to not give that bill a favorable report.
Yeah.
And you offered some very powerful testimony as well in opposition to this bill.
Yeah, well, as you mentioned, medical abortion is not a benign process, and you mentioned all the psychological ramifications. But medically, it's a very dangerous. It's not just like, taking antibiotics for a strep throat. This has significant consequences, and in addition to killing the unborn, studies show that there's 4 times greater risk to the woman than a surgical abortion, that they can have serious complications if they take this home with them and they take the pill. They may have a tubal pregnancy, an ectopic pregnancy, and if they rupture that, they can have hemorrhage and severe infection. In fact, traditionally, the FDA, the Food and Drug Administration, has put this particular drug, which is called mifepristone or RU-486, which is the so-called abortion pill. They have put this in a special category called the Risk Evaluation and Mitigation System, or REMS for short. And they do this for any medication that is potentially seriously harmful and is particularly dangerous. So they're glibly, the writers of this bill are glibly just saying, oh yeah, go to the student health and get this abortion pill. Well, when I read, I'm very familiar with this because I have helped women in my practice reverse the abortion pill. If you give women, after they take this RU-486, and you give them progesterone, the RU-486 is an anti-progesterone. So if you flood the system with progesterone, this will help reverse the effects of the RU-486. So I know that this drug can be given up to 9 weeks of pregnancy. I have 2 daughters and who are grown up now, and the idea of them going to college and taking this pill and sitting on the toilet and passing a recognizably human fetus is just disgusting, and not to mention what it would do with dorm mates. So this, and they, when you and I were at the hearing, they were trying to make it sound like, oh, this is no big deal, it's just taking a pill, and they make it sound like a very benign process. It is not benign, and I really doubt that any university will want to take the PR hit of one of the co-eds dying in a dorm from hemorrhaging or and this happens. People die taking this abortion pill.
And even worse, with a depression, a clinical depression of a kid who goes through this,
yes,
and jumps off a roof or something.
Yeah,
the potential exposure is, apart from the damage to the young woman and her family and their loss. But I agree with you. I don't think it makes sense for a public institution to put themselves in that posture of potential huge, serious legal ramifications,
right,
and a very bad public relations image as well. But you also were challenged by the same senator who you referred to earlier, who went after me,
yeah,
with outrageous claims that she had to correct lies in testimony that you had provided about the effectiveness of the abortion pill reversal regimen and so forth. And it was just a terrible display and breach of decorum for the whole proceeding.
Yeah, it really was, and especially I was not given an opportunity to respond to her claims that these were lies, And I especially was incensed by this since I dealt with this sort of thing in trying to fight this in my practice. So I know full well the ramifications of medical abortion. And she, as a non-medical person, was very blithely saying, "Oh, these are all lies that you're saying," and not saying how they were lies.
No.
But just parroting some talking points from Planned Parenthood or some organization that this is not a big deal.
Exactly.
So it was very very instructive in so many ways to go through that hearing. But anyway, this has been a terrific review of all of these bills and all of this legislation, and I thank you very much for first of all submitting the bills and then to taking the time to explain them to our listeners. And I know you're doing this in other venues also. Any last comments about this?
Well, I want to thank you and your listeners for their time and attention, and encourage them to reach out to their legislators. Legislators hate getting phone calls from their constituents, and when they get phone calls from their constituents, they do pay attention, and if they get enough on a certain issue, they pay a lot of attention. So it's never a waste of time to make a phone call. All of these legislators whom I mentioned, phone numbers are available on the website. If you go to masslegislature.org, and you can pop up and click on either House of Representatives or Senators, or you can find my legislator. You put in your address, and it will take you right to the page with your representative's contact information. So it's fairly easy to track them down, but it's definitely worth the effort. Thank you, Mark, for the opportunity to bring these issues to your listeners' attention, and hopefully we can generate some additional support for this important legislation.
Yes, thank you. And just in closing, I reiterate what you say about listeners going to malegislature.gov to find their representative, and to go to masscitizensforlife.org to find out more about these bills and other great information. So thank you very much, Pat. I really appreciate it.
It's been my pleasure. Thank you for having me.
This concludes my conversation with Patricia Stewart, Executive Director of Massachusetts Citizens for Life. Remember, we should always treat life with care and respect, and at the very least, we should first do no harm.
First Do No Harm with Dr. Mark Rollo is produced at WQPH 89.3 FM, Shirley, Fitchburg. We are very happy to share it with other networks.
Thank you for tuning in to First Do No Harm. Dr. Rollo welcomes your questions and comments. You may contact him at markrollo978@gmail.com. That's MARKROLLO978@gmail.com. Thank you, and until next week, remember, first do no harm.